know, 4 days before they came. I assumed that I would be getting those documents. I typically do get everything that I need. In that particular case, I did not receive the educational records, but prior to receiving those records, Commitability really the court is looking for that opinion fairly quickly. And so I started my interviews with him to assess that. But when I received the documentation, I didn't have the educational records, and thus I stopped.
Okay. Did you author a report regarding Mr. Taylor's committability?
Yes.
And who was this report prepared for?
It was prepared for the court. I sent a copy to the judge as well as to both attorneys.
Okay. I'm going to pass a document to you. Oh, it's her. You all have it? Is it? You don't have a copy of the committability? Okay. That's fine. My apologies. I thought that would pass along to the state. Do you recognize the document in front of you?
Yes.
And what do you recognize it to be?
It is my response to the committability issue.
Okay. Give me 1 second. Your Honor, I would like to enter the 2021 Committability Report written by Dr. Mattai as an exhibit, and this is the copy for the court. All right. In 2022, did you administer a competency restoring training assessment on Mr. Taylor?
Yes, I did.
And how did things evolve into Mr. Taylor undergoing a competency restoring assessment?
Typically in the community, in this particular case, Vanderbilt did a competency assessment and deemed that he needed to undergo some training, and so the referral came. My best understanding is that that referral goes to the Department of Mental Health and Substance Abuse, which then came over to our department.
Okay. And did you author a report at the conclusion of your assessment?
Yes.
And do you remember the date in which your report was published?
It was January the 5th, 2023.
Okay. I'm going to pass you another document.
How do you get committed if you didn't have a opinion?
Your question again?
You said you couldn't make a determination whether he was committed.
Yes.
Why are you doing additional training?
The training was specifically for competency training.
Someone
The
else
first
did that. Someone else determined that he was.
Vanderbilt did their assessment and referred him to DIDS for competency training. When I did the committability, that was like a year or so before.
Right.
And so that's
What
separate.
happened with Mr. Taylor and Diaz or anyone else between 21 and 22?
That I don't know.
Okay.
And Judge, just for clarification, Dr. Mathai went forward with the competency training post receiving the order from Judge Dalton requiring a further evaluation.
Right, I get that, but go ahead.
In your competency training report, how many times did you list meeting with Mr. Taylor in an attempt to restore his competency?
We had 5 sessions.
Okay, and how long did each session last?
Each session was an hour.
Okay. And was Mr. Taylor still incarcerated when
Yes.
you met him?
Yes.
Okay. And how were these sessions conducted? Were they in person or virtually?
It was virtual.
Okay, virtual. Okay. Did you receive any sources of information prior to evaluating Mr. Taylor in fall of 2022?
I had 2 of Vanderbilt's psychological reports, the 2021 and the 2010. I also had Donna Moore's psychological evaluation of 2010. I had affidavits, I had arrest records, I had the CGIS data.
Okay. And you reviewed all of this information?
Yes.
Right. Were you privy to Mr. Taylor's school records?
No.
Okay. Did these sources of information impact your overall opinion regarding his ability to restore his competency?
Did it impact? I mean, it had some bearing. It wasn't the predominant way of assessing whether he could become competent.
Well, I guess what I should have said was that you considered the information in rendering your own opinion.
Yes.
Okay. And obviously you referred to these sources of information in your report.
Yes.
Correct? Okay. Per your report, what was your ultimate opinion regarding Mr. Taylor?
That he was not competent to stand trial.
Okay. In your report, you wrote additional information or records may modify the information or opinions. Did you ever receive any additional information or resources other than what's listed in your report?
No.
Okay. So the opinion that you just relayed that was in your report, it never changed. This was your opinion throughout. Okay. Also in your report, you reference the tool you used to try to restore Mr. Taylor's competency. Which tool did you utilize?
It was the Slater method.
And what is the purpose of the Slater method?
It was a tool designed out of Rhode Island at the Eleanor Slater Hospital. It was designed specifically for this population to try and restore people who had an intellectual disability to competency.
Okay. Did you frequently use the Slater method prior
Yeah.
to assessing Mr. Taylor?
Yes.
Okay. And you just testified that it was specifically designed for those with ID.
Yes.
Okay. And is the Slater method exclusively for those facing criminal charges? Or is it predominantly used in the
It's
criminal legal
used-
setting?
I would, to know exactly how or why they designed it, I mean, it is designed specifically for people for competency issues.
Okay. Let me ask you, how does the Slater method ensure that a examinee or whatever is not simply parroting back the information learned during the session? Like, how does this tool ensure that, this person just won't be regurgitating?
Well, there are a number of guidelines in the way that you go about doing the training. They have the questions, they have appropriate answers or responses that people can make. You ask open-ended questions. You don't ask leading questions. The way that you talk with that individual is to use simple language, to use concrete information. Repetition is also a part of the design of that tool.
Okay. And this case was stated during the cross-examination of Dr. Brown, but in your report, you cite Dusky versus United States,
Yes.
right? And in your report, do you explain Mr. Taylor's level of competency through the lens of Dusky versus United States?
The Slater method divides it into two prongs, basically. One is a foundational competency, and the other is decisional competency.
Okay.
And with foundational competency, you're looking specifically at one's ability to take factual information that's based on the tangible. It's concrete information. With decisional competency, you're asking the person to take that foundational information and apply it to a broader context.
Okay, so to kind of parse out what you just testified to, in assessing Mr. Taylor's competency and just competency overall, there are two prongs. You look at it through a foundational competency lens and then a decisional competency lens.
Correct.
And during the foundational competency component, what's going on in that phase? What's being asked or what is expected of the examinee at that point?
So you're looking at, can the person, do they know their charges? Do they know their pleas? Do they know the consequences of those pleas? Do they know courtroom personnel and what those roles are? For example, like, what's the purpose of one's attorney? What's the purpose of the other attorney? Do they know probation? So it's all of that type of information that you're teaching.
Okay. And per your report, you wrote that Mr. Taylor met the requirements for foundational competency.
Yes.
Let's shift to decisional competency. Now, you gave like a broad overview of it, but what's happening in the decisional competency piece? Like what's going on, what's being expected or asked of the examinee?
So what's being asked is, can he say what his rights are? If he makes a guilty plea, does he know what he's giving up? Another is, can he state what the advantages and the disadvantages are of a plea bargain? So it's taking all of the terms that he's learned, and now let's apply it to your situation.
Okay, so it's specifically tailored to the person's current situations, not hypotheticals that are removed from what this person actually has going on right now.
Well, in my training, I do both.
Okay, and why do you do both?
I use hypotheticals to see, one, if there's any anxiety about talking about, his situation, that looking at another unrelated, scenario might help reduce that, and I can see whether or not his answers change or are they the same.
Okay. In your report on page, give me 1 second. On page 4 of your report, you wrote that Mr. Taylor does not have decisional competency given a series of choices to assess reasoning ability, he identifies the correct option but was unable to explain that choice. Finally, he could not remember and articulate the risks and benefits of a particular action. You go on to say, same page, when asked what happens during a trial, Mr. Taylor responded, a trial is like to see if I do the crime or something like that, to see if I'm guilty or not guilty. How did Mr. Taylor's response lead you to finding that he lacks competency? How did this response particularly kind of help you form your opinion regarding?
Well, it wasn't just this one particular response. It was a pattern of responses where he could talk in very broad, concrete, simplistic ways, but there was no depth to any of his answers. To ask him, why is a trial not needed with a guilty plea? Well, he knows what a plea is. He knows what the judge does, but he attributes that to the judge having made a decision, when in fact it's his decision to plead guilty. I think another example was, again, with the advantages and disadvantages of a plea bargain, he ends up saying, and this is after a lot of training, that you get more time with a plea bargain, which typically is not true. So it was a combination of his responses that were assessing, can he put information together and make a decision to problem solve, that I didn't see he could do.
Would he also exhibit difficulty in answering the question that was asked? It's like in the example that I gave you about when you said what happens during a trial, it seems as if he gave you the definition of what a trial is. Is that something that you saw throughout or struggled to answer the question that was asked?
Yeah, and specific to that, I was talking about the process, not the final outcome. That, you would have his attorney would stand up and speak for him and advocate for him, and the district attorney is going to try and prove that he's guilty and that he's competent. Even in general terms, he wasn't able to make those kinds of statements.
Is it common for those with an intellectual disability to struggle with decisional competency and or abstract thinking or concepts?
Yeah, that's very typical.
Okay, so Mr. Taylor's performance, would you say it was on par with those who are similarly situated?
Yes.
On April 13, 2023, you testified before Judge Dalton regarding this same assessment. During your direct examination, you testified that educators have struggled with teaching abstract concepts to people with intellectual disabilities. Why do you think there's difficulty or significant difficulty in teaching abstract concepts to those with ID? I know that's a loaded question.
I went through, educationally, I went through an education program, and for a period of time, I was licensed as a teacher, but I haven't done that work in a long, long time. But I do have people, educators, consultants in the Department of Education with whom I would consult with, and that, they agreed that it was that particular ability to problem solve, to integrate new information was very difficult for them. And usually what you end up doing is you see that in terms of adaptive behavior, functional behaviors, they do learn, and that can continue in one's life. It takes a lot of repetition, but if they're motivated and you've got a good teacher and whatever, you can learn. The decision making is very, very difficult.
And is this part of why when you testified in April 2023, you were saying just in your experience you haven't seen significant progress in decision making within this population?
Not with decision making. With adaptive behavior, yes, but not with decision making.
Did Mr. Taylor's language impairment factor into your conclusion?
It did somewhat, but I didn't have detailed information about that, so probably not a whole lot.
Okay. Regarding your ultimate opinion, was your findings similar to the findings of previous evaluators in which you received their report?
Yes, they are.
Did you administer any effort testing?
No.
Okay. Did you administer any validity testing? I know they're one and the same, but did you?
No. No
why not?
formal tests, no.
Why not? Why no formal testing?
Because I did not, as I was working with him, I did not see the need. One, there was no collateral information that would indicate he was malingering or feigning. There was no, in listening to him talk, I didn't see any mental health issues that would be affecting it. My questions were open-ended, so that he would have to generate he couldn't just give me a yes or no. Also, he was cooperative in answering all of the questions.
And that's what I was going to say next. On page 2, you wrote Mr. Taylor was cooperative and receptive to inquiries during all sessions. Effort was made to learn the presented material. Give me 1 second. In the reports that you reviewed prior to assessing Mr. Taylor, or during the process of assessing Mr. Taylor, did the mentioning of validity tests ever appear in those reports? Meaning, did any of the prior evaluators ever administer a validity test?
I don't recall. I'd have to look at the reports again.
Okay. Let me ask you this. In your opinion, is the existence or non-existence of prior effort or validity testing crucial when deciding to administer your own effort test on an examinee?
I would expect that any licensed psychologist is always going to be looking at that. Whether or not they give a formal test is going to depend on that relationship and as the interviews progress. But certainly informally, I would expect them to be doing that, to be assessing it.
And when you say informally, you mean looking for the typical behavioral signs of malingering or,
yes.
Putting forth poor effort. Let me ask you this. So taking what you just said, it sounds like you're saying that validity testing or effort testing shouldn't be just blindly administered. I mean, you should have a basis for why you would want to administer a formal validity test.
Every psychologist is going to do something a little bit differently. I mean, certainly you might find a psychologist that just automatically gives one. But again, I would expect that regardless of whether a formal test is given, that they would be assessing that issue.
Okay. And given that, assessing that issue and looking for these behavior signs, given a great deal of deference to what they're observing with this person in person, like
Yeah.
all that. Okay.
Yes.
Give me 1 second. Those are the questions I have for you. Thank you so much. The state may have some questions. Yes.
Looking at the clock, see whether to say good morning or not, but it's just barely, so. Let me just first, the timeline. You talked about having a referral from Vanderbilt Forensic Psychiatry to do competency training. Is that your recollection?
Yes.
Okay, so if we have a letter dated September 18th, 2021, authored by Dr. Wood, which she says, quote, "Thus competency training is not recommended." Do you recall seeing that letter?
Not offhand, no.
Okay. And actually what happened wasn't that Judge Dalton issued an order notwithstanding this September 18th, 2021 letter. She issued an order directing competency training. And that was what got you involved.
Okay.
Or,
I assume so, yes.
well, now, I don't want you to assume anything,
No,
I'm just
well,
saying if you don't recall.
I don't.
But if the record reflects that that was the step-by-step the process, Vanderbilt said he doesn't need it, that it wouldn't be effective. Judge Dalton disagreed, entered an order directing you to do competency training.
Okay, yes.
All right. And that's why you saw Mr. Taylor for 5 hours over a period of a month, correct?
Correct.
Okay. And you saw him virtually, i.e., he was at the jail or a detention facility, and you were at your office.
Correct.
Never saw him face to face in person, correct?
Correct.
And with respect to what is your understanding, to make sure we're all on the same page, what is your understanding of the Dusky Standard?
I would be hard pressed at this time to tell you that, because I haven't looked at it. I mean, I haven't looked at it.
Okay, if I misread this,
Go
I'm
right
sure
ahead.
someone will quote, "Whether the accused has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether he has a rational as well as factual understanding of the proceedings against him," close quote.
That, yes.
All right. I'm just saying, does the word decisional competency in anything that I read?
No.
Now, one of the things too, along those lines of your competency training, you say you use the Slater method.
Yes.
SLATER, is that how it's spelled?
Yes.
Okay, and what is that method? Is it limited to 5 sessions and you give up?
No. It's, I've done it in fewer sessions. I've done it in more sessions.
Isn't it accurate to say the Slater method is intended to be ongoing?
To the extent that the person is learning, yes.
And so after 5 sessions, you determined that Mr. Taylor had stopped learning.
He had learned well in terms of foundational knowledge, but in terms of decisional knowledge, we weren't going anywhere.
Okay. Decisional knowledge, we'll come back to that.
Okay.
Slater method. But before I move on to that, the interim assessment was, and your data report was October 4th, 2021, to determine his committability.
Yes.
And based upon lack of records, and correct me if I'm misstating this, based upon lack of records, you could not determine that he had an intellectual disability for him to even qualify.
I had secondary information, but I wanted, and I pretty much hold the line to wanting to see the actual records.
Okay, fair enough. And that's why you said, quote, "I am unable to conclude that he has an intellectual disability and that all available alternatives to judicial commitment have been met." Correct?
Correct.
All right. So that's two separate decisions that you have to make. And it stops with, if you cannot determine that he has an intellectual disability, he is not by law committable to the Harold Jordan Habilitation Center. Is that correct?
Correct.
All right. And at the time, the Harold Jordan Habilitation Center had what, 4 beds?
That I don't know.
Okay. And the second part, all available alternatives to commitment have not been met. Is that your way of saying that there are less restrictive alternatives, such as the jail?
You know, I really don't remember.
I was just trying to see what you
Right,
meant
right,
by
I
that
understand.
statement. Or was it that, in your opinion, he wasn't a danger to himself or the community?
It would not have been the latter. It would not have been because I thought he wasn't a danger. Let me look at the report.
That's fine. And I guess my question, bottom line question is it your opinion that the jail, or that a jail, is less restrictive than the Harold Jordan Center?
The jail I see that as being more restrictive than the Harold Jordan Center.
But in any event, he remained at the jail.
Correct.
And once you receive the order, or whatever mechanism for you to do the training, at that time, you received all the information that you felt you needed about the actual factual allegations. Would that be correct?
Are we talking about the training?
The training, yes, ma'am.
Okay.
The training.
I still had not received any information on the educational piece.
Well, I understand the educational piece. What I'm talking about, where the Dusky standard requires a defendant to have a factual understanding of the case, correct?
Yes.
So that, would it not be true that the evaluator would also need a factual understanding of the charges before they could assess his factual understanding?
Yes.
And you did not have that, did you?
What I had were the evaluations, and I had affidavits and an arrest record.
And did Mr. Taylor understand that he was charged with a crime?
Yes.
Or actually 4 crimes?
Yes.
Now, I noticed in one of the things you say that you received a court order. That would probably be the court order that we're talking about from Judge Dalton, directing you to do the competency training. Correct. And then the Vanderbilt's evaluations of 2021, and the May 2010, and the evaluation done by Dr. Moore.
Correct.
All right. Do you recall if any of those were the report generated by Dr. Brown, Dr. Kimberly Brown?
Offhand, I don't remember.
Okay.
I know one had to be from Dr. Moore, but I don't know if the other was from Brown or Moore. I don't recall.
All right. And just for the purpose of the record, you said CJIS data, that's Criminal Justice Information System data, correct?
Yes,
His arrest record.
yes.
And another thing, if you have your report there, on page 3, when we get down to the data considered, where he discusses about my charges, the proof. You say he knows, he being Mr. Taylor, knows the outcome for each verdict,
Yes.
correct? I.e., guilty means it's like I did the crime, not guilty means that I didn't do it.
Correct.
And that is correct.
Yes.
So far as, those are the choices of what a trial, on page 4, a trial is like to see if I do the crime or something like that, to see if I'm guilty or not guilty. That
Correct.
is the purpose of a trial, correct?
Yes.
Right? Do you know of any other purpose that he should have known? And
Okay, but my question wasn't about what is the purpose of a trial. My question was what goes on, during that trial.
so what would be the response that you would have wanted him to say to that question?
If he had just acknowledged, that the attorneys are going to argue the case, that his attorney is going to stand up and support him and defend him, whereas the district attorney is going to try and make him guilty. Anything along those lines. And this was something that we had talked about. It's not a question made in isolation.
So in other words, if he parrots that back to you, that would be sufficient for him to be competent?
Well, I'm typically asking open-ended questions, and that's to prevent any parroting, for him to not learn a set response to questions.
Well, when he says that his attorneys are to try to stand up for me, to fight for me,
Right,
that's what they're doing,
right.
correct? He's
Correct.
right about that. And that the opposing attorneys are against him, basically.
Correct. What it doesn't, he gives the definition, basically, of what the attorneys do. That's foundational competency knowledge. But putting that together is, now you're trying to integrate that, which he doesn't do.
Well, he had it right about the judge, didn't he?
Yes,
When he said the judge's role is to listen to both sides, and the judge ain't on nobody's side.
correct.
What additional information beyond that is he required to know?
Again, that goes back to being foundational information. And he learned that. There was some that he already knew coming in. He had had training from Vanderbilt. He also learned a certain amount from the training that we did. But when it comes to putting it together, it's like, again, if you look, when asked a trial is not necessary with a guilty plea, he says, because the judge has made that decision. When in fact, the judge didn't make that decision. He's making that decision.
The decision of whether to plead guilty or not.
Correct.
But it's the judge's decision as to whether to accept the plea or not, correct?
True.
Okay. So, he may be right about that.
Let's hope the legal system
Well,
is.
are you aware that a trial judge can refuse to accept a guilty plea?
True.
Let's talk a little bit about this decisional competency. He knows, does he not, that he can have a jury trial if he wants.
He knows the purpose of a jury trial.
And that it is his choice whether to go to trial or plead guilty.
True.
And those may be his only two choices, correct?
There's a plea bargain.
Well, that's to plead guilty.
Right.
That's
right.
one option. Other than going to a trial, what are the other options?
I don't know if they are the options.
So in essence, he has two choices.
Yes.
And if the state refuses to enter into a plea bargain with him, he only has one choice, or maybe zero choices, correct?
Correct.
And so in that instance, he would not have a decision to make.
On the front end, when he's having to make decisions as to how he wants to proceed.
And is that not part of the responsibilities of his attorneys to advise him?
Yes, it is. And it's also the fact that he needs to be able to understand that.
Okay. And so, would it not then be incumbent upon attorneys, or Mr. Taylor, or really any attorney, to explain things to their client in terms that are understandable?
Yes. However, his understanding is very simplistic. It's very concrete. And so when you start to give, okay, these are your possible options, these are the possible ways that we can go, he doesn't understand that. That's like taking your discrete information. Yes, I know what my attorney's supposed to do for me. Yes, I know what the judge does. But it's in making decisions, it takes more problem solving, more integrating of information in order to make a decision.
Okay. And where is that in the Dusky Standard?
I almost need to have those words in front of me.
If counsel doesn't object. And while that's being passed up, do you consider the Dusky standard, this is from your professional opinion,
Thank you.
a high standard, low standard, or no standard?
I've never thought about it, in terms of, in those terms. It's certainly not a high standard, I guess. Perhaps a low standard, somewhere between low and medium, when you're looking at whether the accused has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding. Reasonable doesn't mean that the person has to know everything. I get that. But they do have to at least have some understanding of what their choices are, of it being able to put together this discrete information. And I think when I say discrete information, yeah, you can define terms, but if you don't know how to use them, if you can't follow from one train of thought or from one piece of information to link it to others, then you don't understand.
And that's your interpretation,
Yes.
correct? Would you agree or disagree that the more contact an individual has with the legal system, the more they should be expected to learn?
I don't know about expected, but I wouldn't be surprised if they learn more. And I would say that, when I was doing my training with him, yes, he learned from prior training, and my guess is that being in jail, one would talk with other people and also pick up information.
And having actually been to court on other occasions
Sure.
and entered guilty pleas. Correct?
Sure.
And that goes back from the sieges information. You saw that
Yes.
had occurred. Now, he got 4 out of the 5 hypotheticals right. Correct?
Yes.
But you discount that.
No, I don't discount it at all. The question was trying to get at his ability to reason. The scenario, you had 2, maybe 3 sentences to a scenario, and then you had a forced choice. You have one of 2 statements that you have to choose which is the more accurate of the 2. So he said, A is correct. And yes, that's right. But that's not the purpose of the question. The question is to get at, can you tell me why that is, which he could not do.
And what I want to ask is, were any of these hypotheticals based on the facts of the charges against him?
In the examples that I give, no. But in the training, yes, I did ask decisional questions.
Again, going back to the Dusky standard there in front of you, does it require that in those words that he have?
It talks about a rational understanding as well as a factual understanding. I'm saying he does have factual information, but he doesn't integrate or synthesize information in putting it all together.
Let's just say hypothetically, if Mr. Taylor were to be accused of a crime that is on video and he watches it and sees himself there at the scene, would that again be a factual understanding?
Yes.
Okay. And if hypothetically he were to say to the effect of, well, I know I said it was self-defense, but I don't see that on the video, that would be a rational understanding as well, correct?
Possibly.
One last area, Doctor. You are not one of the named defendants in the civil lawsuit brought by Jillian Ludwig's family, correct?
Yeah, I think I was.
And that was based upon your finding of incompetence, of Mr. Taylor's incompetence, and his non-committability, correct?
Yes. Well, I didn't assess him for committability.
Okay, correct.
Okay.
I'm just saying what the suit
Yes.
alleges.
Yes.
That's all I have.
Briefly, Dr. Dr. Mathai, I know the state harped on the standard in Dusky and threw out the word rational a lot and not seeing decisional in the standard, right?
Correct?
But honestly, those words are interchangeable. Like rational, decisional, they all come down to the same thing, right?
Yes.
Okay, so doesn't matter if Dusky didn't have the word decisional in it, it had rational, and they both point to the same capability or inability for a person to integrate ideas into a situation, correct?
Correct.
Okay. I want to talk about the commitability report. You didn't have an opinion because you didn't have information pointing towards the intellectual disability.
Correct.
So in January of 2023, a report was issued by Dr. Lofton, who did do a commitability assessment on Mr. Taylor.
Correct.
And Dr. Lofton found that Mr. Taylor didn't meet the criteria for committability, correct?
Correct.
And Your Honor, I have a copy of that Dr. Lofton's letter if the court would like it, and I can enter into an exhibit if need.
Do you want to make it an exhibit?
I can.
Okay. And before we number that, were you, Ms. Odie, going to make Dr. Matthi's report from January of 2023?
Yes, Your Honor, if I didn't, I apologize.
Okay.
Did I provide the court with a copy?
Yeah, you have one?
Yes, I do.
All right, make that report.
The first one is the Dr. Lofton's, and the second one is Dr. Matthias.
All right. 6 and Dr. Longton, 7.
Judge, could I ask you, that also includes the October 4th, 2021 report
The committability one?
authored by Dr. Matai?
The committability one?
Yes.
Yes, I gave it
You
a
got
copy.
the letter, just not the report.
Oh,
The letter.
and
So-
the January 5th, 2023?
Yes, he has one.
Oh,
That's
Mhm.
what we
should
just
be
made.
great.
Yeah, it is.
Sorry. Thank you.
Okay, no, you're fine. So ultimately, again, with the committability, you couldn't do it because you didn't have the information, but in January 2023, Mr. Taylor was evaluated by Dr. Lofton, who assumingly had all the information to render a decision regarding a decision was rendered. He testified in April
Yes.
2023,
Yes,
and he made a finding and said he wasn't committable
correct.
under the same statute, the 33-5403. I could be misquoting, but the same statute
Yes.
you operated up under. Okay. Now, the state reference and cross some of the answers or responses that Mr. Taylor was providing you as it relates to the foundational piece, correct?
Yes,
And you agree that your report says he met that component.
yes,
Okay. So no problem there. He provided answers that allowed him to cross that threshold.
yes,
Okay. And also in April 2023, just hitting on that, the foundational piece, you testified that those with intellectual disabilities often do not have issue with learning the foundational piece because it's concrete, correct?
yes,
Okay. And when talking about improvement, you said it was in your experience back in April 2023 before Judge Dalton, you stated that in your experience, you've seen those with intellectual disabilities improve in their foundational competency.
yes,
Okay. So the fact that, and backtrack, the state, I'll ask you about, well, his constant exposure to the criminal legal system, doesn't that help him learn? But wouldn't that also, whatever information, if every time he's going to jail, he's learning about probation or someone's telling him what probation is or whatever, that plays into foundational competency, right?
yes. it
Okay.
does.
That doesn't deal with his decisional competency,
Correct.
which you stated that someone like Mr. Taylor, the odds of them improving are low. Well, in your experience, it's hard for them to improve in that area, decisional competency.
Correct.
And the examples that you put up on the decisional competency piece, and when the state was asking you, well, he knows if there's only two options, plea or trial, those are only two options. Your take was it's deeper than that because you're assessing, can he aid in his own defense, correct?
Correct.
And can he take this foundational information and have an informative conversation with his attorney, correct?
Yes.
And this is why you came to the decision that you did, because he could not, from your observation, he could not participate in the necessary conversations to be had with his attorney in working through his case.
Correct.
Okay. Give me 1 second. One second. I'm refer to my call. That's all I have. Thank you so much, Dr. McDowell.
Any other questions?
Just to expand briefly, hopefully, lawyer says briefly, and decisional functioning is something that Mr. Taylor does outside of the criminal justice realm, correct?
I'm sure he has opportunities to, yes.
Well, an opportunity to decide whether to carry a gun or not, correct?
Yes.
The decision whether or not to shoot at someone or not.
Yes.
The decision whether to go to work that day or not.
Yes.
And whether the decision to carry a gun and shoot at or shoot someone may not be a appropriate decision, that's one that he makes for himself, correct?
Yes. And I'm not assessing whether or not his decisions are good ones. I'm assessing whether or not he's able to take the foundational information and assist his attorney in making a decision for him.
Certainly. But the decisions that he makes on a daily basis in the free world are choices, correct?
Yeah. And I would think that most of those decisions are very simplistic. They're very concrete. They're things that you can see, you can touch, you can feel. They're not necessarily decisions about more abstract, problem-solving kinds of information.
Which would be along the lines of, after I have shot someone, how do I get out of this?
I'd have to think about that. I don't, maybe.
That's all.
Any other questions?
No, nothing.
All right, thank you. Step down and give that top sheet, I think the state may want it back, I don't know. Okay, who would the next witness be?
Your Honor, if I call them right now, it would be Dr. Mary Elizabeth Wood. About 1 o'clock, I might have a very brief civilian witness potentially here, but right now, it would be Dr. Wood. And I can do that now if you're on the list.
Okay.
Call Dr. Mary. May the testimony may be live first.
Right, I
Yes,
understand that, I'm gonna let y'all take a break while we have a 1 o'clock 404B hearing on the trials that Monday. We can hear from her until then. That's all.
Good morning. Would you state and spell your name, please?
Yes, it's Mary, M-A-R-Y, Elizabeth, E-L-I-Z-A-B-E-T-H, Wood, W-O-O-D.
And where are you currently employed?
I am an assistant professor of psychology and philosophy at Sam Houston State University in Huntsville, Texas.
And what are your duties there?
I am a faculty member in our doctoral program, our clinical PhD program, where I am a director of a research lab. It's the Psycholegal Assessment and Intellectual Disability Lab, which focuses on sort of contributing to academic scholarship in this area. I supervise doctoral students conducting therapy and assessments in a community clinic. I teach graduate level courses, including intellectual assessment, as well as a graduate level practicum. I'm currently teaching an undergraduate intro class and a history and systems class. I serve on dissertation committees, master's thesis committees, and I mentor graduate students in my role there at Sam Houston.
And prior to accepting that position, where did you work?
I worked at Vanderbilt University Medical Center in the Department of Psychiatry and Behavioral Sciences for just about 7 years.
And what was your title when you were employed there?
I was an assistant professor of psychiatry and behavioral sciences. I was also a member of the Vanderbilt Forensic Evaluation Team, and I was a faculty member in the Vanderbilt Forensic Psychiatry Clinic.
And did I hear you say that you did that for about 7 years?
That's correct.
And are you a licensed clinical psychologist?
I am.
How long have you been licensed?
I've been licensed since 2017.
Is that both in Texas and in Tennessee?
That's correct.
And as a subset of that, are you also a forensic psychologist?
I am trained as a forensic psychologist, yes.
Would you tell us a little bit about your training, please?
Yes, I earned my bachelor's degree in psychology from Kennesaw State University in Georgia. I then went on to earn a master's and a doctorate degree in clinical psychology from the University of Alabama. My graduate training was at a concentration in psychology and the law, meaning I did courses and I worked at practicum sites and did research at this intersection of psychology and the law. I also worked in my mentor's lab, Karen Salakin, and her lab was intellectual disability and the death penalty, so we did a lot of research specific to diagnosing intellectual disability in the legal system and some of the issues that arise there. After I completed my graduate training at the University of Alabama, I completed a one-year internship at Patton State Hospital, which at the time, and I believe it still is, the largest forensic hospital in the country, followed by a one-year postdoctoral fellowship also at Patton State Hospital.
And do you have any areas of specialization?
Yes, I would say that my primary area of specialization and expertise is in the area of intellectual disability and the legal system.
And what specialized training do you have in that area?
Yes, so I mentioned I worked in a lab when I was in graduate school, and my mentor, who I had direct one-to-one mentorship by and supervision by, is, I would say, probably one of the leading, if not the leading, expert on intellectual disability in the legal system, especially specific to death penalty proceedings. And so I was directly trained by her, and I had an opportunity to work with her on research and publishing articles. I also, at various practicum sites while I was in graduate school, the majority of the patients that I saw for therapy or assessment were those hand-selected that had intellectual disability because of this interest. I also, while I was at Patton State Hospital, focused as much as I could my training on this population. So I worked in a social cognitive rehabilitation program called the RISE program. I worked with our neuropsych service on identifying folks in the hospital who had these types of impairments. We worked on sort of developing a competency assessment instrument for this population, all of which sort of occurred before I finalized my training.
And have you published any papers about competency evaluations for people with intellectual disability?
Yes, I have several publications specific to this area.
And what topics did those papers address?
So I would say probably the most relevant is an article that I published with some colleagues from Patton State Hospital back in 2019. This article was basically arguing for the applicability of the Americans with Disabilities Act and reasonable accommodations to evaluations, assessment, and treatment of defendants with intellectual disability in the legal system, particularly those that were seen for competency evaluations. And in that paper, we essentially argued that this population is categorically different from their counterparts and ultimately require us to do things differently as sort of a profession and a court system. Subsequent papers have included ones that I think has been mentioned here today, is one in 2024 that was published in Psychology, Public Policy, and Law. That was a review of a couple hundred cases that we saw in Vanderbilt between 2014 and 2021, all of whom had a diagnosis of intellectual disability. I also published in, I think it was 2021 or 2022, an article reviewing the psychometric properties and essentially the efficacy of the only competence assessment instrument that's been designed for defendants with intellectual disability.
And have you conducted any trainings in the area of competency for people with intellectual disabilities?
Yes. Since I started at Vanderbilt in 2017, Vanderbilt's History of the Service does sort of an annual training for the court system. So new attorneys in Davidson County who are beginning to take these cases, when I started, added sort of a 10 to 15 minute training every year where I would come in and talk about what is intellectual disability, what does it look like, what does it not look like, why should you care, who should be referred, things like that. And that was an annual sort of component that I provided in Davidson County every year from 2017 to 2024. I also, when I first started here, we did a several-hour training at the Vanderbilt Law School, which included the Public Defender's Office, the District Attorney's Office, and I believe some other court personnel were invited. And at that point, I think it was an hour-and-a-half long presentation on intellectual disability in the legal system. I've also been invited to do trainings on intellectual disability and competency. So the first was through SAMHSA, which is a federal mental health agency. I did a webinar a couple of years ago on this particular topic. I've done state trainings for state forensic evaluators for the state of Utah, the state of Michigan, and the state of Maryland, specific to defendants with intellectual disability who are seen for competency evaluations. And most recently, I did a national webinar on this population as well through the University of New Mexico's Law and Mental Health series.
So that's both national trainings and statewide
Correct.
state trainings.
Yes.
And so competency in people with intellectual disabilities is an area of focus for you.
Yes, and has been for quite some time.
During the course of your career, approximately how many forensic evaluations have you conducted?
I would estimate between 1,500 and 2,000.
And have you testified here have you testified here previously in Davidson County courts as an expert?
I have, yes.
And have you testified in other counties and states as well?
I have, yes.
Have you testified as both a state's witness and a defense witness?
Yes, I've been called by both sides.
And have you previously been declared an expert in the field of forensic psychology?
Yes,
Have you ever sought qualification as an expert and been denied?
I have not.
I'm going to hand you a document. Do you recognize that document?
Yes, yes, I do.
And what is that?
This is my CV.
Your Honor, I would like to make this CV an exhibit to Dr. Wood's testimony. And at this point, I would tender her as an expert in the field of forensic psychology with a specialty in the area of intellectual disability.
Any questions on that request from the state? Okay. Go ahead.
Thank you. Dr. Wood, you performed a forensic evaluation on Mr. Shaquille Taylor,
Yes, I have.
and that was in relation to charges stemming from the shooting of Miss Jillian Ludwig on November 7th, 2023.
That's correct.
And after that evaluation, did you form an opinion as to his competency to stand trial for that offense?
Yes, I did.
And what is that opinion?
My opinion was that he did not have sufficient capacity to proceed with the charges against him, or in other words, I'm concerned that he is not competent to proceed.
As far as you're aware, has any expert who has evaluated Mr. Taylor ever offered an opinion that he was competent?
I have not seen an expert ever offer that opinion about Mr. Taylor. No.
And did you draft a report that states your finding and conclusions in this case?
I did.
I'm going to pass you something. I've passed you a document. Do you recognize it?
I do recognize it.
Does this appear to be a copy of the report you issued in this case?
It is, yes.
Your Honor, I'd enter this as the second exhibit to her testimony. Next numbered exhibit. Dr. Wood, how did you come to be involved in this particular case?
Our office at Vanderbilt received an order on November 14th of 2023, at which time the case was assigned to me to conduct an evaluation of Mr. Taylor.
So this was a request for the Vanderbilt Forensic Evaluation Team to evaluate Mr. Taylor for competency.
Correct. It was an order, I believe, signed by this court. Yes.
And is that a typical way for you to become involved in a case?
Yes, it's a very standard procedure that's been, as Dr. Brown testified, in place for decades at this point.
What does the Vanderbilt Forensic Evaluation Team do?
We, as mentioned earlier, have a contract where we conduct all of the court-ordered forensic mental health evaluations for Davidson County. For the most part, for adults, that's general sessions and criminal court both. Primarily consist of competency to stand trial, mental state at the time of the alleged offense evaluations. There's other types of evaluations that we conduct as we get further down the line that relate to sort of commitment, for example, following an insanity acquittal. We also do those same forensic evaluations for the juvenile court.
Does the Vanderbilt Forensic Evaluation Team work for either the defense or the prosecution?
We do not. We are considered friends of the court as we are ordered to do these evaluations by the court directly.
So it's a neutral party that does this type of evaluations here in
Yes.
Davidson County.
The purpose of that is that, yes.
Now, as part of that process, once that initial order is received, does the Forensic Evaluation Team request information from both the state and the defense?
Yes, it is our standard process after receiving an order to draft a letter that goes to both the defense and the prosecution saying we would like information and sort of have a standard list of information that we request from both sides. We also send out requests of information to other agencies, like for example, Davidson County Sheriff's Office, we request jail records, Mental Health Cooperative, Middle Tennessee, etc. So we're requesting records from a variety of sources But we also write that letter directly to both sides requesting information.
I'd like to show you something. Showing you a document. Do you recognize that document?
Yes, it looks familiar.
Is that a copy of an initial letter that was sent by the Vanderbilt Forensic Evaluation Team to our office in this particular case?
Yes.
And that requests the information that you talked about.
Yes.
And a similar letter would have been sent to the state.
Yes.
Your Honor, I'd ask to make that an exhibit to her testimony. And did you receive information back from the parties in this case?
Yes.
Was that from one party or from both?
From both parties.
So you received information from both the state and the defense.
That is correct.
Is it fair to say that you're willing to review any information that the parties provide to see if it has a bearing on your evaluation?
Yes, it's an open request, and we routinely consider information that comes in at any point during an evaluation or after.
So to this day, you're still willing to do that?
Absolutely, yes.
Now, even before you received the evaluation request in this case, was the Vanderbilt Forensic Evaluation Team familiar with Mr. Taylor?
Yes.
How so?
So there was the first evaluation that Dr. Brown testified about earlier this morning that was back in 2010. And then I conducted a previous evaluation of Mr. Taylor myself that was back in 2021. And so I was also personally familiar with Mr. Taylor.
So he first came to the attention of the Vanderbilt Forensic Team in approximately May of 2010?
That's correct, through the juvenile court.
And so he would have been about 15 years old.
Yes.
And then he was evaluated again more recently.
Yes, in September of 2021.
And that was in a separate case.
That was in a separate case, yes.
And did you personally conduct that evaluation?
I did personally conduct that evaluation.
And you wrote a report in that case?
I did.
And you testified previously in court in that case?
Yes, twice.
And why were you assigned to evaluate Mr. Taylor again in this case?
So our office, I would say there's really two reasons. The first of which is that while I was at Vanderbilt, routinely cases where their intellectual disability was an issue would be assigned to me just based on the area of my expertise. But also because I'd seen Mr. Taylor previously, we tended to keep defendants with the same evaluator because of the benefit of having been familiar with this individual, having reviewed the case, and having that background and sort of baseline knowledge going into a new evaluation.
So you could potentially see if a defendant being evaluated was consistent with previous evaluations or if that person had changed in some way.
Those are absolutely data points that I'm looking at. Yes.
In this case, after you received the initial order requesting the evaluation and sent out the letter seeking information, did you review records for Mr. Taylor?
Yes, I did.
Is reviewing records a typical part of a forensic evaluation?
Absolutely.
And did these records include school records,
They did.
records from the Department of Children's Services,
Correct.
records from the Vanderbilt University Medical Center,
Yes.
Davidson County Sheriff's Office records?
Yes.
And you listed those records in your report.
Correct.
And later, after you drafted your report, as this case continued on, were you able to review some additional records?
Yes.
Did you later receive and review Social Security records,
I did.
Centerstone records,
I did.
some Chipotle employment records?
I did.
So those may not be listed in your report because of when it was drafted, but you reviewed them.
Reviewed them since, yes.
Now, while preparing this evaluation, did you also review reports from the prior evaluation from 2010?
Yes, I did.
Did you have a report from Dr. Brown
Yes.
and also a report from Dr. Donna Moore?
Yes, I did.
And what was Dr. Donna Moore's role in the 2010 evaluation?
So Dr. Donna Moore was the expert that worked for DID, or I don't remember the acronym at the time, but she was the mental retardation or intellectual disability specialist that received the referral after Dr. Brown referred Mr. Taylor to them.
Did you also have a separate report from another evaluator from the 2021 case?
Yes.
Was that a report from Dr. Jenny Matai?
Yes, it was.
And do you know Dr. Matai?
I do.
In 2021, where would she have been employed?
She was employed at the Department of Intellectual and Developmental Disabilities, or DID.
And did she also evaluate Mr. Taylor as part of that 2021 case?
Yes, she did.
And is it typical for forensic evaluators to review prior reports from other evaluators when conducting a forensic evaluation?
Yes, that's absolutely standard practice.
And are all of these prior evaluations discussed in your most recent report?
Yes, I summarized each one of them.
Now, after you drafted your report, you also received reports from the prosecution experts in this case.
Correct.
You received a report from Dr. Thomas Schuck
Yes.
and a report from Dr. Tucker Johnson.
Yes.
And you were able to review those reports as
I have
well.
reviewed both of those reports, yes.
Overall, in Mr. Taylor's case, do you feel you had the records necessary to fairly evaluate him?
Yes.
Were there any records in this case that you felt were necessary but that you did not have?
I would not have issued an opinion if I felt like there was information missing that I needed to do so. No.
And after you compiled records, did you meet with Mr. Taylor?
I did.
How many times?
I met with him twice.
And how long were those meetings?
It was in total about, I think, 2.5 hours.
And do you remember when you met with him?
December 7th of 2023 and December 18th of 2023.
And did you meet with him again later for a separate commitment evaluation?
Yes, I met with him briefly on January 31st of 2024, specific to the issue of commitability.
And you'd also met with him during your 2021 evaluation?
That's correct.
Was that on September 16th of 2021?
It was.
For about an hour and a half?
Correct.
Is that a fairly typical amount of time to interview a person for a competency evaluation?
It depends on the issue and the defendant in the case, but it can be, yes.
And you've had access to meet with Mr. Taylor more times if you felt it was necessary.
Yes.
Did you meet with Mr. Taylor in person or over a video monitor?
I met with him virtually.
And are you concerned that meeting with someone virtually would affect your results?
So there are cases where virtual meetings, I think, do threaten the validity of the data that we get. But those cases are pretty particular, specific issues. In the case of Mr. Taylor, especially in this most recent case, because I was familiar with him, and it was an environment in which it was free from distractions and he was engaged, I did not feel that it was necessary, or I did feel that the virtual evaluation was a sufficient context to conduct this evaluation.
And do you feel that overall, in the course of these meetings, you were able to fairly evaluate Mr. Taylor's abilities in terms of his competency?
Yes.
When you meet with Mr. Taylor, what do you do?
So a standard process in doing the competency evaluation is to begin with a standard notification. And that notification essentially is to explain who I am and why I'm there, the context of the interview. So in particular, the judge sent me, I'm Dr. Wood, I work at Vanderbilt. I explained what we'll be doing, what I'll be asking, and why I'm asking it. I also explain to whom I'll be releasing information. So I explain after the evaluation, I'm going to write a letter that goes back to the court. These are the parties that get it. I typically explain that I also write a longer report, and that could become involved. I sort of go through in detail this process and then ask the defendant to explain back to me what I explained. So that sometimes involves them just spontaneously generating a response. At others, it sort of involves focused follow-up questioning. After that, I then...
Did he understand that?
I'm sorry?
Did he understand?
He understood some things. So I could read a couple quotes if that would help, to sort of talk about his understanding.
Well, he didn't understand, would that affect the validity of your evaluation?
If he didn't understand,
Why you were there?
would it affect the validity of the evaluation? That's interesting. I'm not sure I understand. I mean, certainly
You're saying he doesn't understand the course. How did he understand all of that?
Well, so the information that I'm getting that's required and sort of go through this notification is essentially who am I, who sent me, what am I going to be asking about, and who's going to get information. He did some of it. So an example is the confidentiality.
Go forward with the evaluation.
Yes, with instruction and training. So I would ask a question and he would answer it to some degree. And so, for example, on the second interview, I said, "Is this confidential?" And I sort of had to simplify that. He didn't know what confidential meant, so is what we talk about secret, for example. And then I had to remind him because he said, "Yes, ma'am, it was," and I said, "Actually, it's not." and asked who's going to receive the information, and that's when he said the judge and my lawyer. So there was sort of this back and forth between, yes, he understood to some degree, he required some instruction and sort of re-review of that information before we began.
Couldn't that same slow work process occur in a trial?
Could it occur? Yes, to slow that down and sort of do focused instruction, you mean, with Mr. Taylor? It could, yes.
Would that make him then understand the process?
I think it depends on the issue at hand. So I think if it was something as simple as this person's going to come and testify and this is what they're going to say and something like that, sure, I think we could help provide some scaffolding or sort of work with him to understand and sort of monitor what's happening. I think the larger issue is sort of akin to what Dr. Mathai was testifying about, which is Mr. Taylor's appreciation of what is the meaning of that information, what is the use of that, being able to follow it in real time, I think are the larger issues. And again, it sort of gets to this distinction between the foundational or factual and his reasoning ability, or sort of the grasp of the depth of that information and its larger meaning.
So, after you've done the initial, do you do what's essentially a semi-structured competency interview?
Correct. So before I get to that, I do ask some background questions and sort of
Thank you.
a brief clinical interview for Mr. Taylor. For example, I focused mostly on, it's been a little while since I've seen you, what's happened since then, where you've been living, what have you been doing, things like that, and then move into the competency portion. And the competency portion, just like you're talking about, is sort of structured as a semi-structured interview, largely moving from the domain of competency or sort of domain of information that we need to assess and asking questions that tap into each one of those.
So you're following sort of a general format, but not with scripted questions.
Correct.
And why is it important that the evaluation be semi-structured?
Well, I think there's some benefits to it being semi-structured in the sense, in particular, that you're ensuring that you're addressing each one of the domains. So when you're going through an interview with someone, you want to make sure you're tapping into each one of the areas that they need to know, and sort of making sure you have kind of a comprehensive coverage of the information that Mr. Taylor, for example, needs to understand in a case. It also allows, like you talked about earlier, is when we're doing a repeat evaluation on someone, especially someone with intellectual disability, I'm constantly monitoring how they're performing relative to previous evaluations. In particular, my previous interviews with Mr. Taylor, I'm comparing to his responses now. Have they improved in any way? So an example here is Mr. Taylor in the intervening period from when I evaluated him in 2021 to my evaluation here in 2020, the report that was written in 2024. There had been multiple hearings with testimony from multiple experts, and he'd undergone competency training. And so I would expect to some degree that his understanding or knowledge should have improved over the course of participation in those activities.
Now, during the course of your evaluation, did you conduct any additional?
I'm sorry. Not measurably, no.
During the course of
Where if I were to say, and you went to explain this, hey, the judge that was out there that you don't understand who he is, just release you, would he understand that?
No, and I'd like to sort of explain what happened when I asked Mr. Taylor what had happened with the last case. I asked him what happened with the last case, and he first said that the charge was dismissed. And he explained to me that it was dismissed because the witness didn't come to court. And then he said something to the effect of the police couldn't find the witness. And then obviously that's inaccurate. I testified in those hearings. I'm familiar with what happened. And in fact, there was the competency training that was ordered, and then the commitment issue was addressed, and then there was the order dismissing the charges because of incompetency. And so I reminded Mr. Taylor, actually, that's not really what happened. Do you remember when I testified? And he said, oh, kind of, and sort of went to, it was about if I was capable. And okay, well, tell me what really happened. And then he sort of adjusted this response to reflect what I had just told him about it. However, during a subsequent meeting with him, and I asked him how his previous charges had been resolved, he again referenced the 2021 charges and said that they were dismissed. So again, this is a prime example of asking an open-ended question for Mr. Taylor to spontaneously generate information that he should remember and understand. He was actively involved in that entire process. I educate him and explain what really happened. He acknowledges and says, okay, I get it, I understand. the subsequent meeting, we're back to it was dismissed because the witness wasn't there. And so I think that's probably one of the better examples of the process of his thinking and his ability to acquire and retain information, especially personally relevant information as it pertains to competency.
Does he understand currently today that this hearing we're having is about his intellectual disability?
I'm not sure if he would understand that. I think there's some incredibly complex issues that are arising during this hearing, and I'm not sure that he would know that the purpose of that is this.
During the course of your evaluation, Dr. Wood, did you conduct any additional testing on Mr. Taylor?
I did not do any formal testing other than the semi-structured competency interview that I mentioned.
Why not?
Well, I can't remember who testified to it this morning, but every evaluation that we approach and conduct, as a forensic psychologist, as a psychologist, I am thinking about the context. I'm thinking about the information that I need. Testing in a case like this is typically most often relevant we use sometimes forensic assessment instruments, so these might be a specific competency tool. In a case like this where intellectual disability might be at issue, I might administer some IQ testing. However, I had sort of a litany of IQ tests before that had been administered both in and outside of the forensic system, and so did not feel that that was necessary or important for me to include.
And after your evaluation, do you believe Mr. Taylor suffers from any sort of mental condition?
Yes.
What is that?
I diagnosed it with intellectual disability, which is something he's been diagnosed with since early childhood, consistently.
What is intellectual disability?
So intellectual disability is what we call a neurodevelopmental disorder, which is just a fancy way of saying that it's a disorder that we diagnose in childhood, and it's a disorder that affects brain functioning. Intellectual disability or intellectual developmental disorder, IDD, it is comprised of 3 prongs. We call them sort of diagnostic prongs. The first is deficits in intellectual functioning or IQ. So this means that someone's ability to think and solve problems and reason abstractly, remember and comprehend information is what the DSM says is significantly sub-average. So that refers to 2 standard deviations below the mean, so bottom 2nd percentile of scores. The second, so that's sort of the first prong, and that reflects someone's capacity level or the kind of the ceiling of which we would expect someone to be able to do. The second is deficits in adaptive functioning or adaptive behavior, and this really refers to someone's functioning in different contexts, so at home, at work, at school, in different environments. We think about this from the perspective of how much support is needed. Does this individual engage in self-care? Do they know what to do in an emergency? Is he engaging in behaviors and activities that reflect a level of independence and understanding and essentially self-protection? And so that adaptive functioning is that second prong. And so we think about prong 1 as the ability level and prong 2 is actual behavior. And then prong 3 is that there needs to be a developmental onset. And all that means is that these deficits need to be present during the developmental period, which we tend to think of as before the age of 18.
Do you have to have deficits in adaptive behavior in more than one environment?
Yes. So adaptive functioning we look at as a sort of comprehensive lens. We're looking at individuals functioning across settings, across contexts, and also in the context of support. So how do they respond when we provide supports in an environment?
So it's a combination of factors that are necessary for a diagnosis of intellectual disability.
Yes. I would also say that the diagnosis in that prong 2 in particular, intellectual disability is a disorder that is ruled in on the basis of deficits, not ruled out on the basis of strengths. And I want to clarify this really quick because I think it's an important point, is that adaptive functioning, every one of us has areas in which we are good. We have strengths and we have weaknesses. And when we're diagnosing someone with intellectual disability, it's not as though we're tallying strengths versus weaknesses and we're sort of calculating, well, there's more strengths than weaknesses or vice versa. In fact, we're focusing solely on the deficits because adaptive behavior deficits are what are required to diagnose intellectual disability. That does not preclude someone being good in some areas or having adaptive strengths in some areas. And in fact, most individuals with intellectual disability have adaptive strengths. Many individuals with mild ID in particular get jobs, they get married, they have children, and aren't, observably, recognizably different than you or I in many ways.
Now, why do you feel that Mr. Taylor meets the criteria for intellectual disability?
Well, we talked earlier about the records that I reviewed. We have records for Mr. Taylor dating back to when he was in this developmental preschool. And he was first identified as a child who was developmentally delayed when he was about 1.5 years old, which suggests to me, and I think is supported by the literature, is that those deficits were so obvious and so severe at an age before we would even expect him to have a command of language, which to me reflects the severity of those deficits. He was shortly diagnosed after that with intellectual disability or mental retardation at the time, and this is a diagnosis that he's consistently had since then. It's been given by the school system, it's been given by forensic evaluators, it's been given by Social Security. And these diagnoses, again, reflect these 3 prongs. We have formal standardized test results from early childhood on both IQ and adaptive functioning, and we have records that consistently document deficits in both areas over the entire course of his life.
At an early age, was he enrolled at a First Steps Heads Up developmental preschool
Yes, he was.
for language delays,
Yes, that was what it was initially identified as.
and then for what was called mental retardation, now
Correct.
intellectual disability?
Correct.
And he had his first IEP when he was at Glenn Enhanced Preschool Program.
Yes, at the age of 3.
What does it suggest to you when a child has intervention that young?
So I think to answer this, it's important to comment on intellectual disability overall. So intellectual disability, it's, as I described it, it's these 3 prongs. It requires formal assessment, it requires testing, it requires sort of consideration of information across contexts. It's not something that you can see or hear. So we call intellectual disability, or ID, it's an invisible disability. It's rarely something that you could interact with someone or have a conversation and say, that person has ID. And in fact, many individuals with intellectual disability will go to great lengths to hide their disability from other people. So saying they understand something when they really don't, checking out books in the jail to suggest that they maybe know how to read when they don't, not asking for help when they really need it, sometimes in a deliberate attempt to mask their deficits. What it suggests to me that Mr. Taylor was identified as someone as early as age 3 is that those deficits were so obvious and so severe that they were identified by people who were interacting with him. Again, he was 19 months at the time when he was first identified and sort of referred for testing, which, if you think about what a typical 18-month-old is able to do in terms of language, is very little. And yet, his deficits were so severe and so obvious that even relative to other 18-month-olds who don't have a command of language yet, it was obvious that Mr. Taylor was not developing at the same sort of pathway as they were.
And Mr. Taylor also had his IQ tested during his school years.
That is correct.
He was tested with the WISC Intelligence Scale for Children, 4th edition, in 2004.
Yes, at the age of 9.
Are you familiar with that test?
I am, yes.
Is it reliable in terms of the scores it produces?
Yes, so the Wechsler instruments, in particular the WISC and the WACE, are what many refer to as gold standard assessments of intellectual testing, meaning that they are psychometrically valid and reliable. They are one of the, I think, the most frequently taught instruments in graduate training.
And what was Mr. Taylor's IQ score on that test?
His full-scale IQ at the age of 9 on the WISC-4 was a 56, which had a confidence interval of 52 to 62.
And what does that mean?
So as I mentioned, going back to the diagnostic criteria for intellectual disability, deficits in intellectual functioning, or IQ, are established statistically. And what I mean by that is that Dr. Brown testified earlier this morning that most individuals have an IQ score that falls around 100, and those scores are normally distributed over the course of those scores. Scores that fall 70 or below are scores that correspond to the bottom 2nd percentile, meaning that 98% of individuals on this particular test would score higher than that person. And so that's the threshold for diagnosing intellectual disability. The score of 56 is actually closer to a 3rd standard deviation below the mean.
And he also took a test when he was 10 years old called the Universal Nonverbal Intelligence Test.
That's correct.
And how is that test different than the WISC-4?
So this is a test, it is a similar, it produces a full-scale IQ score, but it is a test that is a nonverbal test, meaning it reduces the influence of language. And so this in particular was administered because the school system said, hey, he's been diagnosed as having a language impairment. Let's also administer an IQ test that essentially removes any impact of language or verbal functioning to see if we can assess what his IQ is when we essentially reduce what's required of him language-wise.
Okay, so, because language scores are an area where Mr. Taylor's weakest.
Yes.
And what was his score on that unit test?
On the unit test, his full-scale IQ score is a 71, which falls at the 3rd percentile.
Were you also able to review some IQ measurements from Dr. Kimberly Brown's report?
Yes,
Those were from 2010,
that's correct.
and she used the Wechsler abbreviated scale of intelligence.
Yes.
And I think you said that, along with the other, was some of the sort of the gold standard, I think you said.
Yes, so the Wechsler instruments are considered the gold standard. I do want to point out that this is an abbreviated measure. So again, it's kind of like a screening test. It's not a comprehensive one, but yes, it's in the same family of tests, the Wechsler instruments.
And what score did he obtain on that test?
His full-scale IQ on that test was a 56, with a confidence interval of 52 to 63, which is identical to the IQ score from the evaluation the year before. Or, I'm sorry, 6 years before at age 9.
Are you concerned that no validity performance measures were conducted by Dr. Brown in 2015?
I am not,
2010.
and that largely relates to the reasons that she talked about this morning. There's questions about effort and validity testing for individuals with intellectual disability as a whole, and we also have few, if any, instruments that are validated for juveniles. And at the time, Mr. Taylor was both a juvenile and had a diagnosis of intellectual disability, along with the behavioral indications that did not raise concerns about effort.
Now, during the pendency of this case, did you also receive some Social Security records from Mr. Taylor?
I did.
Did those records include a score on the WACE-4 test?
Yes.
And what is that test?
So what is the WACE?
Yes.
So the WACE-4, or the Wechsler Adult Intelligence Scale, is a comprehensive measure of intelligence for adults, so age 16 and up. This is, again, sort of the gold standard assessment for adult intellectual assessment.
And he took that test for Social Security when he was 18 years old?
That's correct.
And what full scale score did he receive?
I do not have it written in front of me, but I recall that it was a 63. I do not know the confidence interval without looking at the record.
And you also received a report from Dr. Tucker Johnson.
Yes, I did.
It contained the results of some IQ testing that she did on Mr. Taylor.
Yes.
She obtained a full scale IQ score of 70. So the score is higher than some of the others that were recorded for him.
Yes, it was consistent with the unit score that we talked about, but higher than the ones from the Wechsler instruments.
Does this score surprise you?
Does it surprise me?
Well, let me ask it this way. How do you reconcile this score with the other scores you saw from Mr. Taylor?
Yes, so I think to answer this question, it's important to just talk a little bit about what IQ is and how we measure it. So the nature of IQ assessment is that we're measuring what's called a latent construct, which means it's not like if I go stand on a scale and it tells me how many pounds I weigh, or if I pull out a tape measure and I measure how tall someone is. These are observable, relatively repeated, reliable judgments of things that we can see. They're tangible. In contrast, psychological constructs, especially things like IQ, are latent in that they are not observable, they're not tangible. And we develop instruments that tap into the skills that are based on complex statistical methods like factor analysis. But we develop these tests that are tested and designed and considered valid to assess someone's IQ. Now, because of this, and because these different tests measure IQ differently, it's well established that IQ scores vary to some degree and sometimes quite significantly for the same individual. And so when we're looking at IQ scores for a person and we see that maybe there's some variability between them, we need to consider things like what was the test that was administered, how does this compare to the other tests where scores were generated, when was this normed? There's sort of this idea of the Flynn effect where sort of scores are increasing over time and it just reflects the norms as opposed to actual increases. And so I would say, based on all of this, based on measurement theory, based on what we know about IQ assessment and the literature, the broad field of literature that suggests that IQ scores do vary to some degree, that I am not concerned by the variability in the scores that we talked about that range from a 56 to a 71.
Now, you made a PowerPoint to assist us in explaining Mr. Taylor's IQ scores.
I did, yes.
Would you be able to talk us through that at this point?
Yes.
Just a moment, Mr. Wheaton. Are y'all okay with breaking for lunch?
Yes, Your Honor.
Okay. Why don't you do that till 2:30 on this case? The other one's supposed to take hour or so. Get Mr. McCann, just try to hold Mr. Taylor. And then when we get back, we'll set that PowerPoint up.
Yes, Your Honor. 2:30, Your Honor?